Yes, Judge, thank you. The trial is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the Registry on Dubai on Justice Sir Richard Field's instructions.
Thank you.
We are here for a trial in the matter of TCD 002-2019 before Justice Sir Richard Field. The claimant is represented by Pinson Masons. Lead counsel is Nick Tolley. The defendant is a litigant in person. Thank you.
Well, the defendant is a litigant in person, but their spokesman is Mr. Gopinath Kodoth. Is that right?
Yes, sir. Yes, Your Lordship.
I hope I pronounced your name correctly. Do forgive me if I don't.
It is correct. Yes, Your Lordship. Gopinath Kodoth. Kodoth is my family name.
Well, if I wanted to call you Mr. whatever, would it be Mr. Kodoth?
Kodoth.
Kodoth. Good. Well, thank you very much. Thank you.
All right, sir. Your Lordship.
Thank you both for providing your skeleton arguments in Word at short notice. I've received those. Now, I've had the opportunity to read the pleadings, the skeleton arguments, and the documentary evidence. We're on a slightly shortened timetable because of the time difference between London and Dubai. And I would like Mr. Tolley to open his case really quite shortly on the back of my assurance that I have read the papers and can see what the issues are in this dispute. What I invite Mr. Tolley to do is to make one or two introductory observations as to his client's case and to make any short observations he wishes to in response to the defendant's skeleton argument. I shall hear the evidence of the claimant, which will be in accordance, no doubt, with the witness statement stroke affidavit that has been served. But the maker of that statement must confirm the statement on oath. So I trust your witness is available, Mr. Tolley.
Yes, my lord. He's presently on the call. That was going to be my first matter of housekeeping, whether you'd like him to stay and listen to the openings or whether we ask him to return in an hour or two, depending, to give evidence.
It's going to be an hour or two, Mr. Tolley.
Well, forgive me. Once the openings are done.
Yeah, I think he need not, and in fact, it might be slightly preferable if he isn't part of the proceeding until we need him to give his evidence. I think we're going to need him in about quarter of an hour, 20 minutes.
I'm grateful. In which case, Dominic, do you want to dial off and dial back in at sort of 20 past 12?
Yeah, that's fine. Thank you.
Yes, Mr. Tolley.
Yes, my lord. May it please the court. The first point was just on the housekeeping, just to check that everybody has the same bundle, and that's the one that's dated 16th of May and is around about 700 or so pages long. And just to comment on the bundle numbering, and that's to say that I'll be giving references to the PDF number, but the red numbering is simply for you deduct 4 because there are 4 pages of contents at the beginning, but I can give both references if needs be. But I just want to make one other point before I open the case, and that's just remind the court that there was an application in relation to the witness evidence of Dr. Ahmed Ghali on which the defendant was unsuccessful, and so any attempt by the defendant to introduce evidence from Dr. Ghali will be resisted by the claimant. But with those brief opening comments, I'll now open the case. My lord, this is a simple case on the background of which is set out in the particulars of claim at paragraph 7 which I know that Your Lordship has read. And in essence, there are three elements to the claimant's claim. The first is the payment of the agreed lump sum for the services of AED 130,000. And the second is the payment for the additional services provided, which is for the sum of AED 264,350. And the claimant
264,000.
350 dirham.
350 dirham, yes, thank you.
And the claimant puts its claim for the additional services in two ways. Firstly, in its primary claim, is that it's a claim in contract, and that it's entitled to this money under clause 5A of the consultancy agreement, and I'll come on to that in just a moment. But alternatively, it's entitled to this money at law as a quantum meruit, and we can explore that slightly further as needs be as well. And the final third element of the claim is a claim for interest. This is not a case where no services have been rendered. The report, as I will call it, was provided on the 29th of August 2017, and I won't go through the full chronology, but that can be found in the bundle at PDF reference 320, or as I noted earlier, the red bundle numbering would be 316. And we say that the additional services were in response to both additional information provided by the defendant after the duration of the initial services agreement that had been agreed between the parties, which was a provision of services for around a 4-week or 1 month period, and also following a meeting on the 4th of January 2018, where the backdrop was the fact that despite the report being rendered in a timely fashion, and if it was late, the claimant's case is that was due to the slow provision of information by the defendant, there was still no payment of the lump sum element forthcoming. So any additional work that was carried out, we say, can be deemed to have been instructed additional services. And the consultancy agreement itself refers to the fact that either an express instruction or a deemed instruction can be sufficient to amount to a request for those services to be provided. And I just wanted to make one other short comment about the governing law. Reading Mr. Kodaskella's argument, it seems that the defendant thinks that the governing law is UAE law. The claimant's also put its case in that way.
Yes.
But we also say that it makes no real difference. But if the court were to find that the applicable law is DIFC law,
well, the court isn't going to find that it's DIFC law. Contract provides that it's AED law. Sorry, UAE law, and that's the law that the court will apply.
I'm grateful, Your Lordship. I was only putting it in that way because I think the jurisdiction is clear, but the choice of law a little less so. But in which case, I'll proceed on the basis that it is UAE law that applies.
Thank you.
The consultancy agreement can be found at bundle reference at PDF 14.
Yes, I've got that.
Important. And the report at 116. And just the key provisions really, and I won't go through them in any detail, but at 1.1 of the definitions, there's a definition of additional fees, which importantly refers to clauses 5 and 5A. And I note there the reference to a deemed instruction, which I've already covered. The fee is referred to in Schedule 3 and is where we find the figure of 130,000 dirham. And the standard services are defined in Schedule 2. And I haven't seen any reference in the defendant's argument as to the standard of care that was supposed to be exercised by DGA in this case, but we say that it was to exercise reasonable care and skill as set out at 2.1, where the obligation on the consultant can be found, and we say that DGA did so. And again at 2.2, it refers to reasonable skill and care in conformity with the normal standards of the profession. And the point that the claimant wishes to urge upon the court here is that a report could be provided which was unsupportive of REYAMI's claims in its dispute with its employer in the underlying construction matter, in this case the Abu Dhabi airport. But that wouldn't mean that the report was in any way negligent or in breach of contract in terms of how it had been prepared. That the job of the consultant here was to provide their independent and objective assessment of the quality of the claims, and in fact, more specifically, the job was to do what it said it would do in terms of the services that it said it would provide, and those were set out both within the report and also again, within the contract itself, the consulting agreement, and again within the report. And we say that the report that was provided was reached the appropriate standard of care, was not negligently prepared or in breach. And for that reason, there's no reason that the defendant shouldn't pay the lump sum that was agreed. And I'll come on to address further the additional services in a moment. And the other point is 5.2 on payment refers to a due date of 45 days. There is reference to the issue of payment notices, but if they're not paid, a default payment notice kicks in under 5.4. And we say in this case that the invoice was provided and that payment should have been made 45 days afterwards. And that was in or around October 2017. I can come back to that, but it's in our pleading, in our skeleton argument. And then the final important clauses are at 5A, 1 and 2. And 5A1 at PDF 20 says the client is entitled to instruct additional services, and if the consultant is required to provide the services for an extended period by reason of any material change to or material increase in scope, complexity or duration, these shall be deemed, again that word deemed, to be additional services instructed by the client. And finally at 5.A2 it refers to the rates by which those would be calculated. And we say that those rates have been properly calculated, and this is the appropriate rate that should apply for the additional services, and they're set out at bundle reference PDF page 33.
What document is it at that page? Is it part of Mr. Sharman's evidence, or what? What is it?
It is part of Mr. Sharman's evidence, and it is a series of timesheets that's set out by fee earner, as one would anticipate and expect, the time that was spent on the matter.
Yes.
And that's how we arrive at the sum of that I mentioned earlier of 264,350 dirham.
Yeah.
And just I'm cantering through quite quickly, but I should also mention that in the chronology, my lord, you'll see a reference to the lump sum is for a high-level summary report, and I'll take the court to where I get that from in a second. But there was also reference in the build-up to this agreement to a more detailed report costing 349,750 dirham. And so we say that that's good evidence that the defendant was aware of both the level of the report that would be provided and the likely cost if a more detailed report beyond the agreed scope of services was requested. And we say it was requested here. But I can deal with that more in closing and also following the evidence of Mr. Sharman. So there's only a few more brief observations that I wish to make. But if one turns up the report, my lord, at bundle reference 116.
Now, just help me with this. This again is an exhibit to Mr. Sharman's evidence, is it?
Yes, it is,
Which
my lord.
exhibit is it? He's got exhibit C1, C2, C3.
Yes, it's at 116, and I believe that is. Let me just find the exhibit number for you. 1 second. I think it's DS6.
DS6, just wait a moment. Yes. The first page of that is numbered master 139, current 139. Are those the numbers that you're, do they chime with the page numbers you're giving me?
Forgive me, my lord. It's at 116, and it's actually exhibit C26. So if one goes into the bundle and goes to PDF page 114,
wait a moment.
Of course.
114. 114.
We see a cover page saying witness statement of Dominic Sharman, exhibit C26. Yeah. And if you scroll down, there's a cover email saying please find attached the draft report. And then the report starts.
Sorry to interrupt you.
Of course.
At 114 in the bundle, the electronic bundle I'm in, the page is headed DGA, and there's a sort of logo badge at the top in color. And then there's a heading contents, and then introduction and so on.
Yeah, that's the report. And a couple of pages prior is the cover page, and the following page is the introduction.
No, I've got it. I've seen this document before, of course. I'm just having to remind myself of where it is. Okay. Yes, thank you.
And all I won't give out bundle references because you've read it, my lord. But if one were to read that document again, you'll see the heading is high-level review.
Yes.
The contents matches what was contractually agreed to be provided. In fact, at page 5 of the report, it exactly reproduces the contents of the consultancy agreement in terms of the scope and specification of DGA's works. At paragraph 4, it sets out the electronic folders with the documents relied upon, and that's key in this case because we say there were 4 folders provided at the outset, and that was the basis on which the lump sum agreement was arrived at. But as Mr. Sharma's evidence will show, there was another either 6 or 8, depending where you look. But I'm assuming that was a guesstimate, as it were, of the size of the electronic documents that followed on. And importantly, they didn't follow on during the 4-week commission or even 2 weeks afterwards. They followed on, in some cases, up to 6 months later. And there's also a trail of email correspondence appended to Mr. Sharman's witness evidence, which explains that there was no way that he could review that in the time available, and that it should have come more quickly, and that sending such documents of such volume at a later stage amounts to additional services. But you'll hear more from Mr. Sharman on that, and I can say more in closing. And then just a few more comments on the report. It says at paragraph 7, it has been agreed this report was not to include a detailed review of any substantive matters relating to delay analysis. This will be dealt with later. And there are also emails appended to Mr. Sharman's that say that any detailed as-built, which is a methodology used for delay analysis, would cost an additional 125,000 dirham. But that wasn't the procedure that was agreed to be undertaken in the lump sum stage that we're dealing with here. And it says that again at paragraph 8, the delay analysis will be provided at a later date. And again, at the overview section at paragraph 20 of the report, DGA again say this is an area which will require further review in a separate, more detailed report. And of course, just pausing there, it's just a submission, but everybody on this call as part of this hearing is aware of construction practice, that the nature of analysing claims in a large construction project is that you may provide an overview at the outset and an assessment of the issues in relation to the time for completion and the subcontract programme and the like. But then once you find areas of your claims that require more detailed investigation, it's of course natural to go into more detail, look at more correspondence and so forth. And really my submission here is that on any sensible reading, that the conclusions and assessments it comes to are non-negligent, comply with the contract, and were of the high-level summary nature that was agreed between the parties for this initial scope of work.
Yes.
So we say that it's beyond doubt that the lump sum payment that's sought in this action is payable, and the claimant's proved its case, and we've heard nothing from the defendant suggests otherwise, and we don't anticipate that we will, but we will wait to see from the witness evidence. And so turning to the second element of the claim, and I'm conscious of the clock, so do ask me to slow down if necessary. But the claim,
you're going well. Yes, go on.
I'm grateful. Again, we say this must succeed, and that's because of the timesheet evidence that shows the actual time and money spent by DGA, that they incurred an amount on this job of 394,350 dirham. And if one takes the lump sum of 130,000 away, you get to the claimed additional services amount of 264,350. And that can be seen in the timesheets that I've referred to at bundle reference 34. And that's supported by the evidence of Mr. Sharman that the court will hear, and the emails that he attaches, that the original meetings were very clear in terms of the scope. It was set out in the consultancy agreement. It was only supposed to take 4 weeks, and it was based on the 4 folders that are referred to in the report. When Mr. Sharman's evidence will show that what in fact happened was that far more information at a far later stage was provided. And perhaps the easiest way for me to highlight that at this stage, but you'll hear it from the witness himself, but is to turn up the claimant's chronology, which is at the PDF 317.
317. Right. Wait.
Yes, my lord.
I'm sorry to hold you up. Just wait a moment.
Perhaps it's, sorry, maybe I'm out by 4 on this one. Perhaps if you try 321, my lord, apologies.
Yes, I'm there. 321. Yes.
Great. And there, I should say that we did send this chronology to the defendant, but we didn't hear back. So I called it claimant's chronology, but I wouldn't want to misrepresent it as being agreed. But the claimant says that this reflects the underlying documents that are before the court. And there's only a few key points that I wanted to highlight there. We say that it was agreed at the outset in the pre-contract discussions that this would be a 1-month commission, but that's also made good in an email dated 1st of June 2017, which, if you go over the page, the second page of the chronology, at item 24.
Oh, wait a minute. Wait a moment. If I go over the page in the chronology, I get to number 90.
Oh.
On page 221, which you gave me,
yes,
the chronology, that's starts at item 74, that dated the 20th of September 2016.
Perhaps we have slightly different numbering, but in which case, my lord, if you go back probably about 4 pages,
yeah,
and look for the page that starts with item 16.
Okay. It's that's 318 on my bundle.
I'm grateful. And there, item 24, there was discussion of signing of a discharge letter. This is around the debate for payment, and the defendant wanted a discharge letter, but we didn't need to be distracted by that because it was never signed. And there, Mr. Craig, who was the main consultant on the job, said if this was a case where the commission was 3 or more months, I would happily sign this. Because it's a 1-month commission, I'm a little nervous. And he ultimately didn't sign that letter, but that's just evidence of the fact that DGA at the time were working to a 1-month commission. And it's also reflected in the early negotiations in terms of the proposal for the scope of works.
Yeah.
And the second point that I wanted to make was on the 9th of July 2017, which is, if one scrolls down a bit in the bundle to the next page, at item 42.
Item 42, yes.
There was an email written there where the claimant expressed that at the outset of starting the report that the documents were more than they were originally anticipated. And of course, that in itself isn't necessarily an issue if they were only mildly more, or if the documents came shortly after during the time of the commission or shortly thereafter. But we say that isn't what happened here. And on the 26th of July, which is item 49 of the chronology, the claimant inquired as to why the additional documents were not included with the ones previously provided, and whether any further documents would come. And what then happens is there's a whole series of emails, and the story, if one can put it that way, is that the volume was overwhelming. And we see that on the 3rd of August that Mr. Craig is complaining about the sheer amount of documentation. And it comes down to a situation where ultimately he's being asked to provide a chronology on over 1,000 letters, and he says that simply can't be done. But he does go on and do a great deal of further work, and all of these emails in this chronology are in response to the defendant's further requests. And the backdrop then becomes a situation where the claimant is chasing payment for the original work that it did for the 4-week period, and there's a back and forth, and it's saying that it can't do any further work until it's paid, but it does go on and do further work, provide further drafts of the report, and provide further responses and requests to the claimant, the defendant's request, both from its employees and its in-house legal team, which comes on board slightly later in the piece. And to the extent that one has to put our finger on a document which we say evidences the sort of short summary that I've just come up with, as it were, and I'm very close to drawing to a close now, my lord. There's an email that was written on the 21st of September 2017, which is, I think, 224 of the bundle, my lord.
All right, wait a moment. Yes, 21st.
And I apologise if
yes,
it's
from Paul Craig to Mr. Madhavan.
And that's where we see the reference to the additional information that was provided being more than 6 gigabytes. And there's also reference at other parts of the bundle to it being more than 8. And we say that, based on the points I've already made and what you'll hear from Mr. Sharman, is that the defendant was aware that the consultant was working on an hourly basis. They were aware that this was a high-level report, and that a further, more detailed report, which it could only be of that nature given the nature of the further questions posed, the further documentation provided, and what it was that was requested. They were aware that this would have a cost element, and this was explained to them on a number of times. So I'll leave it there in terms of the documents, and say for all those reasons, we say that the claimant is entitled to, firstly, payment of the lump sum amount. Secondly, either under the contract as the matter of additional services being either expressly instructed or deemed to have been instructed, payment for the additional services in the amount reflected in the timesheets provided in the bundle, or alternatively on a quantum merit basis. And I can address the court further if needs be, but we say as a matter of either UAE law and also
well, you
DIFC.
set it out quite extensively in your skeleton argument as to how you put it on if you like, the UAE equivalent of a common law quantum merit.
I'm grateful.
Now, let's just emphasize this. Just excuse me just a moment. Mr. Sharman's evidence in chief is going to be his written statement plus his exhibits. I'm not expecting you to elicit evidence in chief orally. It's all there in the document. What you'll be required to do is to, first of all, I will administer an oath for Mr. Sharman to take, and you should then get him to confirm his written evidence, and to confirm that, to the best of his knowledge and belief, it is true. And then it'll be, that evidence is then in, and it'll then be for any cross-examination that Mr. Kodov wishes to.
My lord, in which case, I will call Mr. Sharman following Mr. Kodov's response to my opening. I'll just conclude by saying the final element of the claim is that of interest. The invoice was originally dated the 22nd of September 2017. Again, this is all in my skeleton, but issued on the 1st of October. And the payment terms were 45 days, and we say that the claimant seeks interest both for the lump sum and the additional services. And unless I can assist you further, my lord, those are my submissions.
Well, thank you very much, Mr. Sharman. Now, Mr. Kodov, you've got 10, 20 minutes for an opening statement.
Yes, Your Lordship. Your Lordship, maybe let me go to the crux of the matter directly. Mr. Nick already.
Agreement. Yes, just wait a moment, please.
Yes.
Let me see. It's an yes. Yes, I'm there. 4th of June, 2017. Yes, which clause? Which paragraph? Yes, Mr. Kodov, which part of the agreement do you want me to look at?
No, Your Honor, my submission, opening submission only. Opening submission only. Let me submit my, the crux of the matter. I mean, not a close, crux of the matter. I'm not going, going back to the what Mr. Nick submitted before the court. I'm going straightly going to the crux of the matter. Important points in the matter.
Yes, certainly.
Yes.
Yes, carry on.
Your Lordship, may pleased to see that the claimant had failed to provide a service as per the scope of work. It is more fully described in Schedule 2 of the agreement. That is our definite case, Your Honor. On a perusal of this work in the schedule, Your Honor, pleased to, in conjunction with the report filed by the claimant, Your Lordship will well understand that the report filed by the claimant are not in conformity with the scope of work. But the so-called reports of the claimant, no purpose of
Mr. Kodoff, I know I put you under a certain amount of time pressure, but just slow down a little bit, if you would, because I'm taking a note. There will be some, but I'm just taking care. You say the report is not within the scope of work. Yes, I know that.
Let me start again, sir. On a perusal of the scope of work in the Schedule 2 of the agreement, in conjunction with the reports filed by the claimant, Your Lordship will well understand that the reports filed by the claimant are not in conformity with the scope of work.
Yes.
The so-called reports of the claimant, no purpose of the defendant was served. Rather, the very purpose for which the claimant appointed was defeated, Your Lordship. Your Lordship, the claimant's report did not contain answer to the critical concern in the scope of work, such as various claims available to the defendant, variation claims available in the project, methods to mitigate the liquidated damages and the penalties that might be imposed by its contractor. Your Lordship may please to see that on account of the inability of a deficiency of services rendered to the claimant on account of inability or deficiency of service rendered by the claimant, defendant could not raise its entitlement in the project before its contractor, namely China State Construction Corporation. Consequently, the defendant has suffered huge loss in the project. So the defendant's company's very existence was in jeopardy, in peril, Your Honor, in jeopardy for some times. And company is still not recovered for the setback received from the particular project, Your Lordship. My case is that if the claimant had applied due diligence and reasonable care in the assigned works as a specialized project management consultant in the region and carry out such a work as per the scope of work, we could have put up our claims before the contractor befittingly and thereby realize our entitled in the project in its entirety. However, to our utter surprise, Your Lordship, and disappointment, claimant had never shown its expertise in the field to reach the level of a professional consultancy company. We completely relied on, when an issue come up, we completely relied upon the consultant to go forward in the project. So that is why we availed the service of this expert. But very unfortunately, they were failed to deliver the goods as per the requirement, as per the scope of work. We centered on our main concern with the claims which were available to us, entitlements, how to mitigate the penalties, how to mitigate the LDs. But very unfortunately, nothing was in the report. The report was only just a narration of the subcontract agreement between ourselves and our contractor, and the communication between ourselves and our contractor. Other than the report is very vague and not related for any purpose, Your Lordship. That is why we were not able to pay the money. Your Lordship may please to see that the reports filed claimant are only a reproduction of the 4 subcontract agreement handed over to the consultant with the defendant, and also a narration of the communication made between everybody. It goes without saying that reports of the claimant are incomplete, Your Honor, Your Lordship, irrelevant, lacking material, and cannot be relevant for the intended purpose. Therefore, we could not pay the agreed consultancy fees, as the report filed by the claimant were no way useful for the defendant by any rate.
Yes.
So even let me come to the additional remuneration claimed by the claimant. Your Lordship, in regard to the claim for additional services, I respectfully submit, Your Honor, that such claim is totally baseless and without any corroborative evidence. In fact, no additional service were provided by the claimant as claimed in the petition. The report filed by the claimant without any essence, in line with the scope of work. Hence, the disappointed defendant had pointed out only the lapses in the report, Your Lordship, immediately on receipt of the report, which was on 3rd of August, again on 20th of September and again on 28th of March 2018. And we never asked to do any additional work beyond the original scope of work. We requested only to clarify the report, only to elaborate the elaborate report with a reference to the main concerns in the scope of work. It was under the above circumstances, defendant has raised clarificatory questions which never be treated as a variation for additional work by even remote imagination. It is quite normal when the report was not in line with the scope of work. It is quite normal that the beneficiary revert back to the contract consultant to clarification, which cannot be deemed as a variation, Your Lordship. That cannot be. So that is very baseless, very cognitive. The allegation of the claimant that he was required to review other documentation which exceeded the agreed scope of work, which included a review of 6 gigabytes of document and which were not disclosed by the defendant during the tender stage, was very deceptive and invented. It is concocted one for only for the purpose of snatching monies from in terms of so-called additional work. And in fact, such documents have been provided upon mutual discussion only, so as to enable the claimant to provide them with a fair report in line with the original scope of work. So much of providing of additional documents cannot be deemed as an additional work or service of Your Lordship. Your Lordship may please to note that evidently no additional report was provided by the claimant, and only because of that, claimant has lost any right to claim for additional payment for alleged services provided beyond original scope of work. No report was provided thereafter after the original report. So they have no right at all to ask for additional remuneration or glorify as an additional work done by them. Your Lordship may please to take note of the fact that the alleged service only a figment of claimant's imagination put forward with the mala fide intention to extract monies from the defendant in the guise of additional services alleged in the petition.
Yes.
It is respectfully submitted to Your Lordship that the claim for additional services has been raised for the first time before this honorable forum. It was not raised earlier. The claimant has never raised any claim for the additional reimbursement before the defendant or before the Honorable Small Claim Tribunal of DFC Court. As a matter of fact, the claimant cannot be allowed to raise such a fresh claim. It has not been raised prior to the litigation or before the Honorable Small Claim Tribunal. Your Lordship may further please note that the report filed by the expert, even though our application to examine.
Wait a moment, please listen to me very carefully. As you know, the court ruled that you are not permitted in the circumstances to adduce any expert evidence. And one of the first thing, wait a moment, one of the first things I noticed in your skeleton argument was a number of references to the individual whom you wish to have as your expert when the discussion took place in an earlier case management hearing. And the order of the court was quite plain.
I fully respecting your Lordship. My Lordship, maybe
I'm sorry, we mustn't be at cross purposes. Just listen for a moment, then of
course. Sorry, Lordship.
I shall hear you. You cannot rely on any opinions that are expressed by the gentleman whom you wish to have as your expert. You have a defense which contains a statement of truth, and your submissions must all be within the four corners of your defense. And so far, your submissions have not placed any reliance on an expert view. You've been making your submissions really in line with your defense, which you're entitled to do. But please don't make any further reference to the views of the gentleman who you wish to call as an expert, but you were refused permission to do so. Understand?
Your Lordship, may I ask you, that expert report will accept as a documentary evidence from our part?
No.
Documentary evidence?
No, because
even though our application was rejected by the Honorable Court.
No, you can't.
Documentary evidence.
Wait a moment. Evidence. The first condition on the admissibility of evidence is its relevance. And if the court has held that an expert report, well, a report which is alleged to be an expert report, is not properly an expert report, then it is not relevant to the issue that has to be decided, because it is not, doesn't qualify as expert evidence. So I'm sorry to have to say you can't make any reference at all to the views that were expressed in that report. But as I've said, you filed a fairly detailed defense, which is supported by a statement of truth. And as long as your submissions are within the four corners of the defense, that you're entitled to make them.
Yes, yes, Your Lordship.
So
Yes, Your Lordship.
don't make any further
May I submit you?
to the expert report.
May I submit you one more? May I submit you, Your Lordship? The expert was appointed as advised by the Honorable Small Claim Tribunal, Your Lordship. So it was filed in the Small Claim Tribunal itself, sir. Your Lordship. It was filed before the Small Claim Tribunal itself, Your Lordship. That can be treated as a part of the evidence of this case.
I hope I've made that clear. That report cannot feature to any extent in the evidence that you put before me.
Yeah, I fully agree with you. But Your Lordship, you have full right to recall any evidence from the lower court, Your Lordship. No. Your Lordship has full right to recall any evidence, any document which was produced before the lower court.
No. These are CIF proceedings. They are TCD proceedings, and the management of this case is entirely within the province of the CFI in the person of myself. And the fact that there may have been reference below in the because in the small claims court is entirely beside the point.
Yes, Your Lordship, that our contract consulting agreement is governed by the law of UAE, even though exclusive jurisdiction was extended to DFC court, governed by the UAE law. That you may please to note that. Your
Lordship. The contract, the agreement, the consultancy agreement is subject to UAE law. That's agreed. Yes.
Yes, Your Lordship. Let me continue, Your Lordship.
Yes, please continue. Go on. Please go on.
I'm avoiding that question completely in reference to the expert. I'm avoiding that question completely, Your Lordship.
Okay.
Yeah. Thank you, sir. Your Lordship may please to take note the fact that defendant had availed the service to claiming company, a company which is having expertise knowledge in the project management service for the evaluation of variation orders, claims and submission, evaluation of subcontract claims and back charges, preparation of evaluation of EOT claims, and advice on contractual remedies and entitlement available to a defendant in the project. However, upon going through the reports provided by claimant, the defendant come to know that such reports contain only a summary of the subcontract between the defendant and subcontractor, and also a narration of the communication exchanged between the defendant and his contractor. You will also please take note the fact that on account of the claimant's failure to provide a report as per scope of work as specified to the agreement, defendant has deprived of its entitlement, which would have been possible otherwise to put up in a befitting manner before the defendant's contractor. The defendant has badly lost the opportunity to defend the contract charges imposed upon by our subcontractor, China State Construction. On a kind perusal of the report filed with the claimant, you will also may find that instead of answering the key scope of work in the agreement, the claimant has either referred back such areas back to the defendant or advised to consult with the legal advice of the client or the defendant. Your Lordship may please note that the above such act of claimant shows that there was a clear negligence or default on the part of the claimant in executing the job assigned. Your Lordship may please note that. Your Lordship, I may permit it to bring to your kind attention the provisions of ELS, that's already argued, which I believe is just improper to submit and squarely up to the fact space. So let me go to the provisions of the UAE Civil. Can I go to the UAE Civil Code, Rona, Lordship?
I'm sorry, you want to go to which?
The UAE Civil Code, which supports our case. Can I mention now or later?
Well, yes, I'm not absolutely sure what this new topic is going to be. So start it, begin it, slow down a little bit, and then I'll be able to see.
I'm summing up. I'm closing, Your Honor. Your Lordship.
Yes, go on then.
Yeah. So under the circumstances, we respectfully submit before Lordship that the claim of the claimant for a sum of AED 1,300 may be dismissed with compensatory cost to defendant. Payment for a sum of AED 264,355 may be dismissed with compensatory cost to defendant. Claim for damages and interest may be also be dismissed with compensatory cost to defendant.
Yes, I follow.
Yeah, that's my submission, Your Lordship.
Thank you very much indeed, Mr.
Yes. Yeah.
Kodal. Thank you very much. Well, we'll proceed now with the evidence of Mr. Sharman, please, Mr. Tolley.
Yes, Your Lordship. The claimant wishes to call Mr. Dominic Sharman.
Good morning, Mr. Sharman. I can see you on the
Good morning. Good morning, my lord.
You may be able to see me. You may well have given evidence on numerous occasions. The way we're going to proceed is this. I'm going to ask you to take an oath. It can be a religious oath on a holy book, or it can be what's called an affirmation, which is a non-religious promise. But what your evidence is true to the best of your knowledge and belief. What sort of oath would you like to take?
The affirmation's fine, my
The
lord.
affirmation. Well, just listen to me then carefully. Do you, Dominic Sharman, sincerely affirm that the evidence you will give, to the best of your knowledge, is true?
Yes, my lord.
Thank you very much. Well, you're now duly sworn, and I'll put you back into the hands of Mr. Tolley.
Thank you, my lord. Mr. Sharman, do you have the bundle in front of you?
Yes, I do.
Can I ask you to turn to PDF page 85, which the red numbering is 81?
Yeah.
Wait a minute. I'm just going to catch up with you. 85. Yes.
Mr. Sharman, is that your witness statement?
It is, Nick. Yes.
Can I ask you to...
Yes, go on, Mr. He's got to confirm his signature, okay?
Yeah, that's where I'm going, my lord.
Okay.
If I ask you to turn to the back, which is PDF page 90.
Yep.
Do you see a signature there?
I do, yes. That is my
Is that
signature.
your signature? Thank
is.
you. Have you read your witness statement recently?
Yes, I have.
And are the contents, to the best of your knowledge, true?
Yes, they are.
And is there anything else that you'd like to add?
Nope, that's fine, thank you.
So,
I'm grateful.
There are no, having read it through, there are no changes or amendments you'd like to make. You confirm it as it is.
Yes, my lord.
Yes, thank you. Now, Mr. Kodal, you may ask questions of the witness.
Yes.
It will be related to what he states in his witness statement.
Yes, Your Lordship. Yes,
And
Your Lordship.
don't rush it. Take it slowly, because we must. Sometimes when you have these Zoom hearings,
Yeah.
the quality of the sound.
Of course, yeah, I respect you.
So we'd all be grateful if you spoke a little more slowly, so that we fully understand what your question is.
Okay.
So if
Let me ask.
you'd like to proceed.
Yes, Dominic. Dominic, good morning. First question. Can you hear me?
Yes, I can hear you.
Dominic, yeah. That first question. You are not the person who made the report as per the consultancy agreement dated 4/6/2017 between REYAMI and DGA. The question, I repeat, you are not the person who made the report as per the consultancy agreement dated 4/6/2017 between REYAMI and DGA.
Okay, what's your question, sorry?
Yeah. Question is, you are not the person who made the report as per the consultancy agreement dated 4/6/2017 between REYAMI and DGA. You are not the person who made the report. Yes or no?
Okay. I guess you're asking me if I did the report. No, I did not. It was the report was carried out by Mr. Paul Craig.
My question is, you are not the person who made the report.
Well, he's
as per the consultancy agreement.
Mr. Kodal, he's confirmed that. He said that he wasn't involved in producing the report, That was Mr. Craig. So we can move on to the next question.
No, yes or no? What's your answer?
So he's answered that question, and he said that he agrees that he's not the person who wrote.
Okay. Let me go to the second question, Your Lordship. Mr. Dominic, you have no direct knowledge with regard to the documents that the maker of the report has reviewed and relayed in making the report. I repeat the question. You have no direct knowledge with regard to the documents that the maker of the reports has reviewed and relayed in making the report.
I don't have direct knowledge. I don't have.
Yes. Okay. Yes.
Can I answer?
Okay. Yeah. Let me go to the Your Lordship. Let me go to third question.
Wait a moment.
Okay. Can I answer that question?
Mr. Sharman has agreed that he does not have direct knowledge with the documents that Mr. Craig reviewed. Okay, so we can move on now. Just take it slowly, Mr. Kodoff.
Of course, Your Lordship. Third question. Mr. Sherman, can you deny if I put it to you that Mr. Paul Craig has not made the report as per the consultancy agreement and the scope of work covered in the Schedule 2 of the agreement? Let me repeat. Mr. Sherman, can you deny if I put it to you that Mr. Paul Craig has not made the report as per the consultancy agreement and the scope of work covered in the Schedule 2 of the agreement?
So can I confirm? What did you say? I missed that?
Well, the question is, I'll intervene. It's put to you that Mr. Craig's report is not within the scope of work contemplated and provided for in the consultancy agreement. Yes or no?
No. Yes, it was fully compliant with the proposal, the consultancy agreement.
Right.
Okay, let me go to the next question, Your Lordship. First question, when did you come across with the documents of this case? When did you come across with the documents of this case?
I was the regional director of the DGA group at the time. Yeah. So I had input in all work that was being carried out by the group in the Middle East region. So I was fully aware of Mr. Craig's proposal, and I verified the proposal. And
probably at what time?
Don't interrupt. No, Mr. Kodoff, don't interrupt the witness. You, of course, are free to ask him questions, but he must.
I'm sorry. I'm sorry, Your Lordship. Sorry, Lordship.
Your question now. He began to tell me that he was regional director at the time, and he had input in the work that was being done in his area. Yeah. And do carry on, Mr. Sharman.
Thank you, my lord. So yes, I had input in all proposals and commissions that was carried out in the Middle East region for the DGA group. Therefore, the proposal that was issued by Mr. Craig was verified by me. We discussed at length the scope of the services and the time frame and cost that we offered to our REYAMI. So I was fully aware from the outset, which was end of March 2017, of the scope of works that we had agreed to perform and on what basis.
Okay. Let me go to the next question, Your Lordship.
Yes, go on.
Repetition of same. I already answered. You had occasion to discuss the matter with Mr. Paul. Yes, it's already answered. So there is no relevancy for that question. My next question. When did Mr. Paul left the Dubai office and did you join with the company?
Okay, so when did Mr. Craig leave?
Left Dubai, yeah.
The Dubai office, and when did you join?
Yes, I was from the outset of the DGA group operations. So traditionally, we have a 30-year operations globally, and I started the office in Dubai in February 2016.
Yes.
Could have been February 2017, my lord, actually. And then we undertook this commission in March 2017. Paul Craig left the DGA operations in the summer of 2018.
Yes, thank you.
Okay. Okay. Mr. Sharman, let question, are you aware of the existence of a tripartite agreement between the defendant, China State, and Auspic Sunshine of Dubai? A tripartite agreement, which is referred, which you are requested to, review that agreement. An agreement entered in between defendant and his contractor, China State, and third party, Auspic Sunshine. We were told to review that tripartite agreement as per the scope of work, which was not done. That is why I am putting that question.
No, that's a lot to let's take it in stages. You're asked, Mr. Sharman, whether you were aware of what has been called a tripartite agreement involving the China State Company and the defendant. I'm not sure who the third party is. Mr. Kodoth, can you help me? You talked about a tripartite agreement. One party is your client, well, your company. The other party was the Chinese state
contractor.
Who was the third party?
Yeah.
Who was? What? Give me the name of the third party.
Third party is Auspic Sunshine, Free Zone, Dubai, Your Lordship. Auspic Sunshine, Free Zone, Dubai.
Are you aware of that company, the Sunshine Company, Mr. Sharman?
In Free Zone.
I'm not. So my lord, I was the regional director of the group. Mr. Paul Craig was a senior director, and he was engaged to manage this commission from the outset. So he was closer to the documentation than I was. Paul is a chartered quantity surveyor and chartered arbitrator with over 25 years experience. So he had the skills and necessary.
All right, but if you forgive me for interrupting you, the question is whether you were aware of this tripartite agreement.
No, I wasn't fully aware of it. No.
Not aware.
So I'm getting that echo.
Your Lordship, what is the answer, Your Lordship?
Who's speaking now? We don't want to hear that. We only want to hear you, Mr. Kodoth, not anybody else. So Mr. Sharman accepts that he wasn't aware of this tripartite agreement that you put to him.
Yes, Your Lordship.
Next question.
That means you don't have an opportunity to review that document. You don't have an opportunity to review that document.
Agreed.
You are not aware of the document and you have no opportunity to review that document.
Okay, now he agrees with that. He agrees with that.
Yeah. Did the report contain a synopsis as per clause A, part 1 of schedule 2? Not aware. Did the report contain a synopsis as per clause A, part 1 of the schedule 2 of the agreement?
Did the report contain a synopsis in accordance with which part of the agreement, Mr. Kodoth?
As per clause A, part 1 of schedule 2 of the agreement.
I'm not aware. Sorry.
Not aware. Not aware. Are you aware? Did the defendant ask the claimant? Are you aware? Did the defendant ask the claimant to review the tripartite agreement and give comments on it? Are you aware? The defendant asked the claimant to review the tripartite agreement and give comments on it.
I'm not aware.
No. I put it to you that, next question, I put it to you that your company has not carried out the assignment as per clause A, part 1 of schedule 2. I put it to you that your company has not carried out the assignment as per clause A, part 1 of schedule 2. True or false? Yes or no?
Sorry, what's your question, Mr. Kodoth?
Yeah.
Did we carry?
Mr. Kodoth, can you make very clear, speaking very slowly, which precise clause in the consultancy agreement are you referring to when you put that question?
It is a clause A, Part 1 of Schedule 2, Your Lordship. Clause A, Schedule 2.
Schedule 2, yes.
Yeah,
In which part
yes.
of Schedule 2?
Part A of
Part-
Schedule 2, Your Lordship. Part A, as per the Part A, Part 1, Clause A, Part 1, the claimant is supposed to review all the agreements, any other agreements.
All right, just pause there for a moment. Mr. Sharman, can you turn up the agreement and have a look at Schedule 2?
Yes, 1 second. What page is that on, please?
So there's a page number for the agreement. It is in Schedule 2, last.
In the bundle.
At the end of the agreement. At the end of the agreement.
At the end of the agreement?
Yeah, last 3 pages. That is Schedule 2, Your Lordship.
Wait a moment. I'm just scrolling through to find the page, the bundle page for Schedule 2.
It's, if I may assist, my lord, it's
24,
24 of the red numbering, or PDF 28.
So page 24 or 28, Mr. Sharman?
Yes, I have it in front of me.
Yes.
And
No.
so what was the question, Mr. Kodoth? Could you repeat that for me?
I put it to you that your company has not carried out assignment as per Clause A, Part 1 of the Schedule 2. Schedule 2 is the scope of service, scope of work.
I don't agree with that.
Not carried out. Not that.
No,
Okay.
I don't agree with your assertion that we did not carry that out.
My question is whether your company has carried out assignment as per Clause 1A, Part 1 of the schedule, which include there is a scope of work. You have to review any other agreements.
Well, Mr.
Any
Kodoth,
other-
the problem, Mr. Kodoth, the problem we're having is we can't identify the precise part of Schedule 2 that you're referring to. Presumably, you have the e-bundle in front of you, do you, Mr. Kodoth?
No, I don't have. I don't have.
Well, is there? I think there's some internal pages mentioned. I think the agreement is 18 pages long.
Yeah.
Which page within the internal numbering of the agreement are you referring to?
Yeah, by the end of the agreement, last three pages, starting with the Schedule 2, scope of service, Your Lordship.
Yes, okay.
Last three pages, yeah.
Yes, well now which, I'm looking at that, it begins with Part 1, high-level report, and then there's an A, and it's a review of the construction contract.
Yes, Your Lordship. Yes, Your Lordship.
Wait a minute, and just so that Mr. Sharman can see, then that says provide a synopsis paper on the construction contract as to the form, parties, amendments, date entered, relevant clauses, entitlements and liabilities of the parties, and any other agreements, unless this has already been carried out. And it's put to you that Mr. Craig's report did not provide what is called for in Part 1, Paragraph A. Your response, Mr. Sharman?
Yes, I do not agree with that. Having read the report, I believe that Mr. Craig's report has covered those points in the proposal, reviewed the construction contract and the scope of services in the proposal.
Yes, thank you.
Let me go. Let me move to the next question, Your Lordship.
Yes, next question.
Yeah. Next question. Have you prepared a reconciliation of the variation account or the values claimed by REYAMI as per Part 1, Clause B of the Schedule 2 of the agreement? Have you prepared a reconciliation of the variation account on the values claimed by REYAMI as per Part 1, Clause B of the Schedule 2 of the agreement of the Council scope of work.
Do you see that, Mr. Sharman, within the agreement?
Mm-hmm.
I think it's page 15, B, high-level review of financial matters. First bullet point, prepare a reconciliation of the variation account based on the values claimed by ARSC, the values as assessed by CSCEC. And the question is, it's put to you that Mr. Craig's report did not do what is required under B.
Now, Mr. Craig's report provided a high-level financial analysis of the project, which was provided on the basis of the information that was given to DGA.
Right. Next question, Mr. Craig.
Okay, let me go to the next question, Lordship. Is my next question: if the report doesn't contain that reconciliation of the variation account, will it not become a non-performance of the Clause B of Schedule 2? I repeat, if the report doesn't contain that, I mean reconciliation of the variation account, will it not become a non-performance of Clause B of Schedule 2?
Well, that question is a matter for me as the judge in the case. I have to decide whether there was a reconciliation of the variation account in terms of the financial analysis conducted by Mr. Craig, and if there wasn't, was that a breach of the agreement? Now, Mr. Sharman says that there was compliance with B, and I have to decide whether that's correct. And then the next question, as I've said, is a matter of law for me to decide whether that would be a breach of B. It looks as if it would be, if that's correct, but that's ultimately a matter for me. It's not a matter for Mr. Sharman. Next question.
Yes, Your Lordship. Have we complied with the Clause D, Part 1 of Schedule by giving a summary of all claims submitted by REYAMI, including time and cost, reason for the delay, identifying compensatory and non-compensatory events?
So if you can look at paragraph D, please, Mr. Sharman, on page 15, first bullet point. It's suggested to you that Mr. Craig's report did not comply with that requirement.
Sorry, which one, my lord?
It's paragraph D. It's paragraph D.
Yes. Review of the contractor's
claim submissions. First bullet point. It suggested to you that Mr. Craig's report did not deal with this matter set out in the first bullet point. What's your response?
Mr. Craig's report dealt with those claim submissions that he was aware of at the time of the report.
Right, thank you.
Okay, so let me go to the next question. Mr. Sharman, have you reviewed the time extension submission made by the defendant? Have you reviewed the time extension submission made by the defendant?
The time extension.
I'm sure. Unsure.
You're not sure?
Not sure.
Right.
But I'm not sure.
Yeah. Next question. Have you reviewed prolongation of the contract and complaints of notices?
Yes, that was reviewed in the report.
Yes. Have you given an opinion about the validity of the delay submission made by the defendant? Have you given an opinion about the validity of the delay submission made by the defendant?
I'm unsure.
The validity of
I didn't draft the report myself, so I don't know. I'm not too close to the technical details of the report, my lord. However, all I know is all the work that was carried out was what was known at the tender stage of the project.
Okay. Have you reviewed defendant's documentation and provide bullet points comments as per clause G.
G.
Have you reviewed defendant's documentation and provide bullet points comments as per clause G of part 1?
I haven't. No, I don't. I'm unsure
sure.
whether the reports cover that.
We're not sure if Mr. Craig's report covers
Yes.
that.
Yeah.
Okay.
Have you provided recommendations suggesting possible defenses against application of liquidated damages and penalties by the contractor of the defendant? Have you provided recommendations suggesting possible defenses against application of liquidated damages and penalties by the contractor of the defendant?
No, we didn't, because we were unable to.
Have you provided your opinion regarding the merits of the claim put forward by the defendant and counterclaim of the China State? Have you provided your opinion regarding the merits of the claim put forward by the defendant and counterclaim of the China State?
I'm unsure. I didn't draft the report myself. It's been a very long time since I've read the technical reports, so I cannot confirm the contents of those reports today, Mr. Godoff.
Well, we're talking about Mr. Craig's report. It's been put to you that these requirements set out in this part of Schedule 2 were not dealt with in Mr. Craig's report, and therefore the report was not within the scope of work.
Understood. So Mr. Craig's report was a high-level report on the issues that are noted in the services in Schedule 2. Mr. Craig, the proposal was based on Mr. Craig's time over a 4-week window, and it was based on the information that we were provided at tender stage. That included several key issues, including financial status, claim status, etc. And we were only able to carry out the services and respond, do a high-level review on those items with the information that was provided to us. We weren't able to provide, or Paul Craig was not able to provide a synopsis on items or issues that he was unaware of and he did not have any information for. Typically, in our operations in the Middle East, we would normally carry out what we believe is a 3-4 week preliminary review, where we would take the information from a party and we would give them a high-level overview, and this would be the structure on their strategy going forward. It would not be it was never intended to be a thorough review of liquidated damages, positions, delays, programs, etc. And of course, we are dependent on receiving the information, and if we don't receive the information, we can't do the review on those items. However, and we based the proposal, the 4 weeks, on the information that we received from the contractor in the tender period of the commission. In situations where we are uncomfortable with the amount of the information, or the contractor is uncomfortable with the amount of information that we would have to review, it's normally an open-ended proposal which is done under hourly commission. However, because of the certainty, the 4 folders that was provided to DGA, we were comfortable that that information could be reviewed and drafted into reports in a 4-week period. And this was the basis on which we costed our lump sum.
Right, thank you.
Yes, Your Lordship. May I go to next question, Your Lordship?
Yes, next question.
Yes, Mr. Chairman. Have you jointly reviewed the report with the defendant and prepared extension of time claim? My question is, have you jointly reviewed the report with the defendant and prepared extension of time claim?
Preparation of an extension of time claim was firmly
have you jointly reviewed with the defendant?
That was not in our proposal to prepare extension of time claims.
Okay. Next question. Have you ever attended the meeting with the China State as the representative of the defendant? have you ever represented the meeting with our contractor as a representative of our defendant? Ever attended a meeting?
I've never attended a meeting, and I don't know. I'm unsure whether Paul Craig attended meetings.
Okay, sir. Okay, sir. Let me put it to you that you have not. Let me put it to you that you have not carried out the scope of work in Schedule 2 of the consultancy agreement, making you eligible for the consultation fees.
Well, you've asked him that question already, and his answer was that in his view, the report was within the scope of work in the particular circumstances, namely that it was contemplated there would be a 4-week review on the basis of 4 schedules.
Okay.
That's his answer.
Yes, Your Lordship. Yeah. Let me go to next question. Mr. Sherman, have you had occasion to review the email sent by the defendant on 3/8/2017, 3rd of August, and the 20th of September, immediately after the receipt of the report, mentioning the point to be reworked? Did you make the required changes requested as per the mails mentioned and resend it?
This was yes. I'm fully clear on those emails.
Yeah.
Well, you were asked whether or not the requested response was produced by DGA, I think.
Yes, the comments were incorporated into the report, and this was still 4 months after the original submittal. And when we received another bundle of documentation, we incorporated those comments into report.
My question is whether we reworked on it, because as per our mail dated certain date, we request you to rework on the point which we mentioned in the mail. Whether you rework on it, because it doesn't contain rework on it, because the report filed by doesn't reflect as per the scope of work. So we request you to redo the work by incorporating the parts, the missed out parts.
I disagree with that. I do not believe you ever requested us to redo the work. It was more an imposition of further information, which lasted over a year, and you never ever once rejected the reports.
No, not rejected. We requested for modification of the report.
Excuse me. Sorry,
we requested for the.
Just to code off. Wait a sec. Just let Mr. Sharman finish, and then if you want to follow up with the question, of course you can.
Sorry, Lordship. Sorry, Your Lordship.
So no, I do not believe you rejected the reports ever. It was more of a request to include further documentation, information into the reports, as and when the information came available. Hence, the emails that you are stating, Mr. Kodoff, was around the time that you provided a further 8 GB of data to DGA to include in the report. We even set out in good faith to you to include this in the report, even though we believed that our services had been concluded. And then we didn't hear, after we'd included those comments, we didn't hear anything from you until nearing the end of the year.
Which was sorry, Mr. Sharman, I'm so sorry to interrupt you.
That's okay.
I've heard of emails dated the 3rd of August and the 20th of September. What year are we talking about?
This is 2017.
17.
20th September 2017 and 20/33/8/2017.
Thank you.
Requested to redo the work, with incorporating the concerns which we raised. Whether you worked on it, did you make the required changes as per the mail and resend it? No.
Yes, it was resent to you after we
incorporated the report. I mean the report.
And you even stated to us that you would pay us on account if we incorporated their further comments into the report.
Yeah, that means you have not reworked on it. We are not accommodated our request to rework on it.
We incorporated the comments. You then came back to us, I believe, at the end of the year or the early 2018 with further comments, highlights, after it had been to your legal counsel. And this was when DGA made a decision that we would stop works until we had at least received the payment of the lump sum. Hence the dispute that we're in today.
Thank you.
Your Lordship,
Yes.
let me go to the next question.
Yes.
Mr. Sharman, are you aware of an email dated 27/12/2017 sent from your office confirming attendance of Mr. Paul Craig in the meeting scheduled for 4th January 2018 with the General Manager of the defendant?
Am I aware of the email? No.
Email dated
Wait a minute,
27.
Mr. Kodoff, I must make a note of this. What is the date of this email, please?
27/12/2017.
27/2.
27/12 December, Your Lordship.
Oh,
27
September.
December 2017.
7th of September 2017. Now, are you able to give me a page reference in the bundle to that email?
No, Your Lordship. No, Your Lordship. It was not produced, Your Lordship.
Mr. Tolley, are you able to help? Where am I going to find that email?
Possibly, my lord, PDF 257.
257. Just wait a moment, everyone.
So it's the internal bundle 253. There are a number of emails on the 27th of December.
Right, 253. Let's have a look. I can't go back for some reason into 25. So it's 253. Let me put that in. No, I'm sorry, on 253, I've got an email of the 3rd of January 2018.
My lord, if you scroll to the bottom of that page, you'll see in the chain, there's an email.
Oh, it's December, is it? Not September.
Yeah.
December.
December, Your Lordship.
December, all right. Let me just look at that, please. It says, thank you for your email and attachment.
Yeah, and it carries on the other side. It was a pleasure seeing you this morning.
Following our today's meeting, please retrieve the below documents and so on. Use the link. Thank you. Manoj Madhavan. Yes, all right. So that's the email that's being referred to. Now, Mr. Sharman, do you know anything about this?
I don't, my lord.
You don't.
Okay. You know, did Mr. Paul Craig attend the meeting on the scheduled date? Are you aware of that? Did Mr. Paul Craig attend the meeting on the scheduled date on 4th of January 2018? As per your mail? No.
You don't know?
I don't know, my lord.
Right.
Mr. Sharman, Ms. Sharman, in the replication dated 16/1/2019, in case number 386 of 2018 before Small Claim Tribunal, you have admitted that reports were not closed or finalized. In para 26, Your Lordship may repeat, in the replication dated 16/1/2019, in case number Small Claim Tribunal 386 of 2018, you have admitted that reports were not closed or finalized. In para 26.
Sorry, I'm unsure what you're stating there.
I don't understand that. Can you refer me to the document in the bundle?
Yes, that is Your Lordship, that is a statement filed by the DGA before the Small Claim Tribunal, Your Lordship, wherein
Mr. Kodoff, I'm entitled to ask you, and so is Mr. Tolley, to relate your questions to the documents which are before the court. namely in the e-bundle. Now, are you able to do that in this case, in this particular question? Because otherwise, I don't know what you're talking about. If you take it a little more slowly, you're suggesting that Mr. Sharman, when it was before the Small Claims Tribunal, made some admission. Now, just tell us slowly and clearly what the admission you say was that Mr. Sharman made in the Small Claims proceedings.
My Lord, before Mr. Kurloff answers that, the claimant wishes to object. The Small Claims Tribunal documents he's referring to aren't part of the bundle. And at the outset of today's hearing, the court made very clear that the matter had been transferred to the TCD. And therefore, unless Mr. Kurloff can point to the document, we asked him to take us to the document before he makes any allegation of any alleged admission, because we say that's simply not before the court.
So can you help, Mr. Kodath? We must see the record of this alleged admission before we can take any further steps on this question.
Yes, Your Lordship.
What I'm telling you is that unless you can show me the documentary record that contains this alleged admission by Mr. Sharman in the Small Claims Tribunal, we can't take your question any further.
Let me read out the portion, Your Lordship. Let me read out. There was a contention raised by us in the Small Claims Tribunal. The claimant has not provided the reports and advice as per services specified in Schedule 2 of the agreement, against which the statement of the DGA is that this is baseless. All reports were provided. The issue was the reports were never finalized due to ARCC continually providing additional information. Over and above that, inedited at the time of the lump sum price, the ARCC's unreasonable request for additional work over a prolonged period of nearly 1 year. Unfortunately, due to this untenable situation and escalating losses, DGA was unable to close the report.
Well, I'm sorry, Mr. Kodoff. Without having this, the precise wording of this document available for me to see and for Mr. Tolley to...
My Lord, I think Mr. Kodoff has left the meeting.
Oh.
I believe.
Yes, it looks as if he has. Let's wait and see if he comes back. I'm sure he will. Well, I'm going to mute for a moment while we wait for him to come back. There are one or two things I can be looking at.
Sorry, Lordship. I'm extremely sorry. Because of technical problems, that's because of technical problems. I'm extremely sorry, Your Lordship.
My Lord, you're on mute.
Yes, yeah. I'm extremely sorry, Your Lordship. I'm extremely sorry.
Yes, all right. And I'm sorry, I was still on.
I'm extremely sorry, Your Lordship. I'm extremely sorry. I'm apologizing.
Well, I'm afraid we can't take that question any further because we do not have the documents you're referring to. So would you like to move on to your next question?
Yes. Mr. Chairman, I put it to you that defendant had lost chance to put up his legitimate claims properly before its contract with China State Corporation because of the deficiencies in the report, and that may sustain huge loss. I put it to you that defendant had lost the chance to put up its legitimate claims properly before its contractor, China State Construction Corporation, because of deficiencies in the report, and thereby sustained huge loss.
Okay, so
Wait a minute,
sorry.
Mr. Kodor, that is a submission. It's not
Okay.
a factual question.
Okay.
It's a submission that, and you
Yes,
you
yes,
make
yes,
that
yeah.
submission in your skeleton argument. So there's no
Yes,
need. You can't put that to Mr. Sharman. I've got the point from your opening submissions and from your skeleton argument.
yes, yes. Your Lordship, I have a few more questions. This is not about original claim. This is additional claims. That is about 15, 16 question, additional claims. Let
Yes.
me go to that. Yeah. This is crossing. For the additional claim, you claimed an additional claim of 264,000 for the additional service rendered. I have some questions, a few questions, about
Yes.
that.
Yes.
Let me ask, what is the basis on which you have made the additional claim? My first question is, what is the basis on which you have made the additional claim?
Well, that's a matter of legal analysis, and
Okay.
that depends on the pleadings and the skeleton argument. Mr. Sharman doesn't
Yes,
have.
Your Lordship. Yes.
So
Let me
move
go
on.
to the next question.
Next question.
What is the scope of work for making additional claim? What is the scope? My question is, and put it to you that, what is the scope of work for making additional claim? Scope of work.
So what was the scope of the additional claim, Mr. Sharman?
I'm unsure.
Next question. Have you made any report based on which you made the additional claim? Have you made any report based on which you made the additional claim?
I'm unsure.
Well, I don't understand the question. So can you?
Yeah. Question is, Your Lordship, have you made any report based on which you made the additional claim?
Still a bit confused. Sorry.
Have you made any report based on which you raised the additional claim?
Well, what you're saying is, have you made in the report?
Any report. My question is, Your Lordship, have you made any report?
Well, are you
saying?
Okay, wait a minute. Are you saying that? Is there within the additional? Is there within the report?
Yeah. In addition to the original report.
Material that amounts to additional work.
Additional work. Yeah.
I think that's what you're saying.
Yeah.
Sorry, could you repeat that question for me, Mr. Kodoth?
Well,
Did you made any report based on additional work done by you? Did you?
The point of this question, Mr. Sharman, is this.
Yeah.
It's being put to you to identify where in the report that you provided, albeit that it was, if you like, an ongoing process, where within the report that you provided by way of an ongoing process, can we see the additional work that you're claiming for?
The additional work was in the time consumed in having to revisit, rework on the documentation and review the information and attend meetings over a prolonged duration. Obviously, our fees are based on...
Can we have no discussion while I'm hearing Mr. Sharman? Yes, go on, Mr. Sharman. Finish
the additional costs and losses to DGA arise from the extended prolonged duration that we had to incorporate and to review documentation. Typically, when we carry out such an exercise, we would take a bundle of information, review it over a certain period, and then draft the report. We carried out the commission like this, and then further information came and further information. So the additional services or additional costs arise from the time consumed.
Yes, thank you.
Yes.
Go on.
Yes. Mr. Sharman, is there any evidence to show that you have reviewed any document after filing the original report? Is there any evidence to show that you have reviewed any document after filing the original report?
Yes, I believe that we submitted further reports to you after the initial draft report?
No. Is there any?
Nothing was. All right, you can't. That's Mr. Sharman's evidence. His evidence is that new information came in and it was dealt with and reviewed and reflected in the ongoing report, so to speak. That's his evidence. You may disagree with that, Mr. Kodos, but fair enough, but that's his evidence. So let's have the next question.
I put it to you that you have not reviewed any document based on which additional claim is made. I put it to you that you have not reviewed any document based on which additional claim is made.
I believe we were reviewing documents. I believe we were reviewing documents throughout 2017, which is the basis of our additional claim, over and above the lump sum amount we originally agreed.
I put it to you that clarification sought by the defendant to the original report is taken as variation or additional work. I put it to you that clarification sought by the defendant by email dated 3/8/2017 and 29/2017 by the defendant to the original report is taken as variation or additional work.
Well, now I've heard of the email of the 3rd of the 8th of 2017. What was the second email you referred to, Mr. Kodos?
Email dated 3/8/2017 and
yes.
Email dated 29/2017 and again on 3/8/2018.
Could you refer to the PDFs in the bundle, please, so I can revert to it easily, Mr. Kodos?
Well, I haven't got the dates down yet. All I've managed to take down, Mr. Kodos, is an email of the 3rd of the 8th of 2017. You then referred to the email of the 29th, but what was the month and the year? The email of the 29th.
29/2017, Your Lordship.
Yes, but I'm so sorry. I just can't distinguish the month that you're referring to. I've got the year 2017.
August and 2017 September.
And September. Okay.
Yeah.
Right. That's
again on 3/8 again on. And again on 28/3, Your Lordship, of 2018. 28/3/2018.
28th of March.
March 2018, Your Lordship.
2018. All right.
Yes, Your Lordship.
So can you repeat the question that you asked me regarding those emails?
So can you repeat your question, please? Now we've identified.
Yes, Your Lordship. Yes, Your Lordship.
Thank you.
Yes, Your Lordship. I put it to you that clarification sought by the defendant to the original report is taken as variation or additional work by you. I put it to you that clarification sought by the defendant by email, aforesaid email to the original report is taken as variation or additional works.
Yes, what's being put to you, Mr. Sharman, is that where clarification is sought, that can't amount to additional work. It's in a sense, it's. I'll just deal with that. What's being put to you is that where you're asked for clarification and you provide clarification, that's all wrapped up in the, if you like, the work that you're doing for the lump sum, and it can't constitute additional work at an additional price. What's your answer to that?
I disagree. To a certain extent, yes, but outside of the original scope, seeking clarification on further additional information that was provided 6 months after the planned submittal date, I believe is, in my opinion, is additional works.
Thank you.
Okay. Next question. Your Lordship, let me go to next question.
Yes, go on.
Yeah. I put it to you that defendant has never requested for an additional work, nor made a request through a variation order. I put it to you that defendant has never requested for an additional work, nor made a request through a variation order.
You requested additional works, yes, under the guise of withholding our payment. You requested additional works. You provided further information for us to review.
We just request for clarification only, not for an additional work.
Well, that's the same point. Go back to the difference between clarification and additional work. Mr. Sharman.
Let me go to the next question, Lordship.
Please, yes, next question.
Have you ever taken consent for a variation of work from the defendant? Have you ever taken consent for a variation of work from the defendant?
Consent of a variation? No, we never took consent of a variation.
No. Has the defendant asked for your consent for doing any variation work? Has the defendant asked for your consent for doing any variation work?
It's the same question, but no, we didn't receive your consent to do variation work.
Yeah, no. I put it to you that under clause 5A of the consultancy agreement, I put it to you that under clause 5A of the consultancy agreement, you have authority to do a variation or additional work without the written instruction of the defendant.
Well, I think that's a matter of the legal construction of the agreement.
Yeah.
So that's a matter for me, and you can make your submissions to me on that in closing.
Yes, Your Lordship.
Not really a matter for Mr. Sharman.
Yeah.
So please go on.
Yes. Let me go to next question, Lordship. Did the defendant agree on any remuneration for the variation work? Did the defendant agree on any remuneration for the variation work?
No, the defendant did not agree on the remuneration of additional work, variation work.
I put it to you that your intention by claiming the additional fees for unlawful enrichment. I put it to you that your intention by claiming the additional fees is for unlawful enrichment.
Right, I'm unaware. That's a legal principle.
Well, what's being suggested to you is that you were acting in bad faith, that you were seeking to enrich yourselves in the absence of any proper basis for the claim. That's a very serious allegation, Mr. Kodoff, and it ought to be made only after very careful consideration of all the matters that are before me. Anyway, what's your answer, Mr. Sharman?
Sorry, my lord?
It's being put to you in claiming for additional work, DGA is acting in bad faith because it's making a claim where it knows it has no justification for the claim.
I disagree.
Yes. Let me go to next question, Lordship.
Yes.
I put it to you that you have not performed the original scope of work as per Schedule 2 of the agreement, and also did not do any additional work, making you eligible for additional compensation.
Well, we've had that. We've dealt with that, and we know what his answer is. You disagree. He disagrees with you.
Yeah. And I put it to you that you are not eligible for any damage, as you are not sustained any damage as alleged. I put it to you that you are not eligible for any damage, as you have not sustained any damage as alleged in your petition.
Well, again, it's essentially a legal submission. Now, how much more have you got to go, Mr. Kodoff?
Yes, Your Worship. Let me go to the next question.
Well, wait a moment. I'm just looking at the timing. How much longer are you going to be in asking your questions?
I have two more questions only, Your Lordship. Only two more questions.
Okay,
Yeah.
put those
Okay.
through, and then we'll
Yes,
see
Your
what they are.
Have you raised a claim for additional claim before small claim tribunal of the DFC court? Have you raised a claim for additional remuneration before the small claim tribunal of the DFC court?
I'm unsure.
Not sure.
Okay.
I'm unsure. Yeah.
Have you issued any claim to defendant seeking additional remuneration? Have you issued any claim to defendant seeking additional remuneration?
Have we issued a claim against the defendant? Yes.
Any claim in the form of a claim? In the form of a claim, I mean.
Well, I believe we're claiming now.
No. Previously, to the defendant before litigation.
So did you launch any proceedings before the current proceedings that began first in the...
I'm unsure. I believe we did. Yes, they went to this SCT, the Small Claims Tribunal.
Well, I mean additional remuneration. It was not raised before, yeah.
I believe so,
Last
yes.
question.
No.
Last question.
Yes.
Last question. I put it to you that you have made a claim for additional remuneration for the first time before this honorable forum, not before. I put it to you that you have made a claim for additional remuneration for the first time before this honorable forum and not before.
No, I disagree. We made the claim in SCT, in Small Claims Tribunal, for additional remuneration as well.
All right. Well,
Yes,
no.
it's close convention over even. Close convention is over.
All right. Thank you very much, Mr. Kodoff. Now, you will
Thank you,
want
sir.
to re-examine Mr. Tolley, and I think we ought to have a break now to give you a chance to review how the cross-examination has gone in order to compose your re-examination. Now, I'm in London time, and in London time, it's a little bit before 10 to 11, whatever the hour is in, what is it, 10 to 1 in Dubai, is it?
10 to 2, my lord.
10 to 2. Well, we will resume at 2:05. I'll give you 15 minutes to review, and we'll have your re-examination. Is that sufficient time, Mr. Tolley?
Yes, my lord.
Yes. All right. Well, I'm going to come out of the hearing and come back in again at 2:05 Dubai time.
My lord, before you go, can I ask we just direct to Mr. Sharman not to talk to anybody in the next 15 minutes?
Yes.
I'm grateful.
Certainly. I don't know whether you know that rule, Mr. Sharman, but where a witness has not completed his evidence, as you haven't, but there's an adjournment, you have to go into a form of purdah. You mustn't talk to anybody, particularly about the case, but it's best that you just have a lonely 15 minutes and then you'll be re-examined.
Understood, my lord.
Thank you very much. Thank you.
Your Lordship.
Just turning my camera on.
Right. I'm very sorry for the delay. Something cropped up which I just had to deal with there and then. So do forgive me for the late start. And so we'll get on with things straight off if we can. Mr. Tolley, re-examination.
Yes, my lord. I'm grateful. Mr. Sharman, I have just a few questions for you in re-examination. You were asked if you were aware of a tripartite agreement with China's state, and your answer was no. If I could just ask you in the bundle to turn to page 258. That's the PDF page number. The bundle number is 254.
Yep.
And I think you should see there an email from Mr. Madhavan to DGA, which begins, following our today's meeting, please retrieve the below documents. Do you see that?
Yes, I do.
You see it, paragraph 2, there's a reference to a tripartite agreement.
Indeed, yep.
My question to you is, on what date were these documents provided?
Well, it would appear that they were sent around December 17.
And do you recall when the tender stage of this project was?
March 2017.
I'm grateful. It was also put to you that the report provided by DGA didn't include a synopsis. You said you weren't aware. Could you just go to PDF page 112, which again is bundle reference 108.
Did you say 112?
Yes, please.
Wait a moment. Yes, I'm at bundle. Yes.
Yes, if one looks at the bottom right-hand corner, there's an email there from Paul Craig to Mr. Madhavan of REYAMI. And my question is, what is the subject line of that email?
Synopsis of reports.
And do you see there that it says in the second line, please find attached a summary of the 4 reports?
I do indeed.
Thank you. And then if one goes to PDF page 130, which will be bundle 126. Do you see there section 5 of the report?
Bear with me. Yes, I do.
And you see there at 5.1 it says outline.
I do.
And if one reads on, the next heading is associated documents at the bottom of that page.
Yes.
And then at 5.3, it's headed general conditions and contractual interpretation.
Correct. Yep.
And my question is, how would you describe the following paragraphs that review the general conditions and contractual interpretation?
Sorry, can you repeat that question, please, Nick?
Yeah, looking at that part of the report, and this is in the context of it being put to you that the report didn't include a synopsis. My question is, how would you describe the summary that you see here running from 5.1 onwards?
It's a synopsis. It's a high-level review.
Thank you. You were also asked whether you'd reviewed the values, I think was how the question was phrased. If you just scroll down to PDF page 137, you see
bundle page.
it's 133, my lord.
Thank you.
At the bottom of that page, you see a subheading called costs claims.
Yes.
And then there's a number of paragraphs that follow. Again, this is in the context of it being said that you hadn't reviewed the value of any claims. How would you describe the contents of the report that you see at that section?
It's a review of the cost of claims.
Thank you. You were also asked that you hadn't provided any opinion in relation to delay. If you go to page 136, so 132 of the bundle, there's a heading time analysis.
132.
So 136 the PDF, 132 of the bundle.
Yeah, time analysis, yes.
Yeah. What, again, in the context of you being put to you that you hadn't provided any opinion on the validity of the delay submission, if you just cast your eye across those paragraphs, what would you say they deal with?
Time issues.
Thank you. It was also said that your report didn't deal with, or the DGA's report, forgive me, didn't deal with the merits of the claim. If you go to PDF page 140, there, which is bundle reference 136, you should see a paragraph 82 just above that. It says potential entitlement to further claim, and it then goes on to discuss elements of the claim and the further claims. Again, my question is, in the context of this being put that the report didn't deal with the merits of the claim, what would you say this deals with?
Potential entitlements to claim.
Thank you. There was some questioning directed at the distinction Mr. Codas was drawing between clarificatory work and additional work. He referred to a number of emails, and one of those was dated 28th of March 2018, and I think we can find that at PDF page 280, which I think is in the bundle at 276. You might just have to rotate the view for a better look at that.
276 bundle page or PDF?
So 280 PDF, 280 of the PDF.
Yes, what are we looking at there? There's
It's an email dated 28th of March, which my learned friend referred to but didn't actually take us to. And it's from Mr. Rajapan of REYAMI Steel to Mr. Craig, the author of the report.
Yes.
And it says, "Dear Paul, this is a continuation of our discussions and teletalks on payments and the report requirement."
Yes.
And it then says, "Our in-house legal team has come out with their comments on your submitted report as mentioned below. Kindly undertake to review the points and rework your reports based on a frame that can enable us to judge charting out the next course of action." I'll stop reading there, but one can see then there's a series of subheadings relating to internal structures, structure erection, roof structure report, and so forth. My question is, can I, first of all, Mr. Sharma, what was the date of this email?
28th of March 2018.
And how long was that after the initial tender period?
1 year.
And in the context of what was put to you, do you think the contents of this are additional work or clarifications?
It's additional works.
Thank you. I have no more questions, my lord.
Right. Thank you very much. Thank you, Mr. Sharma. You're released as a witness.
Thank you very much. Goodbye.
Bye-bye.
So we now move to submissions.
My lord, forgive me. I'm not sure of the practice in the DRC TCD. Is it for the claimant or the defendant to go first?
Well, usually, although the claimant opens, the claimant also opens the closing submissions as well.
If I could just have 1 minute to gather my thoughts,
well,
my lord.
We've done well. We've moved quite speedily, and I'm quite prepared to be reasonably generous about the amount of time that each of you might need, because you've been taken somewhat unawares by the speed at which the hearing has proceeded. And I think, in fact, we will gain time by you having some time now to compose concise submissions, because your submissions will inevitably be coming back, in fact, to the case you made in opening, but you'll be responding to the points that have emerged in the cross-examination and in re-examination. And I think both sides ought to have a further break of about 20 minutes in which I would like you both to consider your closing submissions. There'll be a transcript of this hearing, and I will ask for that to be produced as quickly as possible. It will in particular be useful for the cross-examination of Mr. Sharman. Much of that is fresh in our minds, so you can refer to it in your closing submissions. So what I'm going to propose is that we adjourn again until 1:45, and I'll then hear you, Mr. Tolley, It'll be no surprise to you that I will expect fairly concise submissions because of the detail in your written opening and in your oral opening. And then I will hear from Mr. Kodoth. And if Mr. Kodoth wants a further break to take on board your closing submissions, I shall be receptive to that, subject to reasonableness. And then I'll hear Mr. Kodoth on his closing submissions, and that will bring to an end today's proceedings. Mr. Kodoth, have you followed what I've said? Mr. Kodoth?
You're on mute, Mr. Kodoth.
Mr. Kodoth?
You need to press the little microphone symbol.
Yes, now you can hear me?
Yeah, we can hear you now.
Yeah. Okay.
You followed what I proposed. I suggest that we give Mr. In fact, time's gone on a bit. I'm going to give Mr. Tolley until 10 towards the hour to compose his closing submissions.
Okay.
And then it'll be for you to present your closing submissions. And if you need any further time after you've heard Mr. Tolley, then I'll hear an application for an adjournment of, say, a quarter of an hour or so to allow you time to compose your closing submissions, which I would hope would be reasonably concise, because we've had the benefit of your skeleton argument, much of it you repeated in your oral opening, and your questioning of Mr. Sharman remains pretty fresh in our minds. All right?
Yes, sir.
Right. Well, then we will resume at 10 to the hour. Well, what will that be? 10 to 3.
Correct, my lord.
10 past 3. 10 past 3, Your Lordship.
No, 10 to 3. 10 to 3. 2:50.
2:50. Okay, Your Lordship.
2:50. Good.
2:50.
Thank you both very much. We'll resume then. Thank you.
Your Lordship.
Mr. Tolley?
Yes, Your Lordship.
Good. Are you ready to go, Mr. Tolley?
I am, my lord. In closing, the claimant would direct the court to its points in reply, which deal with much of what Mr. Kodoth has raised in his defence, which can be found in the bundle at bundle reference 63.
Page 63.
Yes, my lord. And I can deal quite shortly with the first head of claim, the lump sum. We say that the defendant's contention that no services were rendered is unsustainable. Yeah. And that the evidence that we heard and the documents show that the consultancy agreement was complied with and the scope of services was provided. And in relation to the additional fee and the additional documents that were provided, the claimant's case is that the evidence showed that the report was updated on a rolling basis, and that the report was first provided in September 2017, but we've heard evidence from Mr. Sharman that a very significant amount of documents followed that date, long after the initial tender period and the date of the report. And in my question in re-examination, Mr. Sharman confirmed that as late as March 2018, there was extensive requests for further work and further review of documents that were being provided at that late date. And we say that the original lump sum was for 4 weeks of work only, and our case is that therefore the time spent in those first 4 weeks, or alternatively the first 7 weeks, because we accept that the report was slightly later than envisaged, but as set out in my written case, the claimant's case is that was due to the defendant's shortcomings in terms of the late delivery of the information required. But the claimant should be paid both the lump sum and the additional services. Now, turning to the evidence of Mr. Sharman, the claimant said that he was a calm and credible witness, and when he didn't know the answer to a question, he said so quite plainly, and when he was unsure, he said so. And we say that his evidence in this case should be preferred. We heard from Mr. Sharman that he was the regional director of DGA at the time, and he explained that I quote, he said, "I had input in all work carried out by the group. I was fully aware of the proposal and the input into all proposals and all commissions carried out, and therefore the proposal issued by Mr. Craig was verified with me. We discussed at length the scope of services from the end of March 2017 and the fee and on what basis this will be provided. And of course, his written statement deals with the fact that Mr. Craig has moved on from DGA, and he confirmed the dates that he was there, which overlapped entirely with this dispute. And of course, and therefore we say it's completely reasonable that the claimant has relied on the evidence of Mr. Sharman. Now, the main thrust of Mr. Koda's initial questioning, and rightly so, was that the scope of services hadn't been carried out, and that was of course denied. And again, my questions in re-examination, Mr. Sharman confirmed that a synopsis was provided, a review of the contract, costs, claims, delay, merits, and so forth. And as the claimant has put in its pleading, we say all in satisfaction of the requirements and specification of the consultancy agreement. The court will have, of course, read Mr. Sharman's witness statement in chief, and we say large parts of this were not contradicted in cross-examination. He explained how, following the lump sum, the position radically changed, and that wasn't challenged, we say. And he notes that it took 7 weeks rather than 4 to provide the first draft at the end of July 2017. And he said it was due to the huge increase in information to be considered. And we heard from Mr. Sharman that they priced this job on the basis of 4 folders, and actually far more information came forth from the defendant. And following this, they did in good faith attempt to review some of the documentation, to carry out some of the work. But the backdrop, which again comes forth in the evidence, was that not only had they not been paid the initial lump sum amount, and an invoice had been raised and 45 days had passed, but the indication in correspondence was that they weren't going to be paid. So this went on for some 5 months until eventually DGA had enough. And as we see, we're here today, and that's a result of a lengthy chain of emails saying that they would take further action if need be and asking to be paid. And there were reminders sent on the invoice was first raised on the 8th of October. I think it's dated 22nd of September. It was first sent on the 1st of October 2017, and it was reissued on the 8th of October, and that can be seen at bundle reference 232. And there were reminders on the 1st and 15th of November, and it remained unpaid. And there was a meeting on the 3rd of Jan 2018. And we heard again from Mr. Sharman, he used the phrase in good faith, that they agreed to review further docs in good faith, and that's reflected in the emails that went back and forth, on the condition that they'd be paid, and they carried out further work, but they were never paid. And the request for further work came in even as late as March, 28th of March 2018, and in re-examination we heard from Mr. Sharman that he considered that very much to be additional work and not merely clarificatory. And we say, as a matter of common sense and the ordinary way in which these commissions are undertaken, requesting a review of over 1,000 letters and the production of a chronology and all the other points, that the subheadings that I read out in my earlier submissions, cannot amount to merely clarificatory work. They must amount to additional services. And I remind respectfully the court of the reference to a deemed instruction of further work in the agreement itself at clause 5A. So the heart of the claim is that the additional work was provided over and above the lump sum scope. And we heard in evidence that the additional work was the time, and again, this is the transcript will show Mr. Sharman said that this was the time consuming of having to revisit, rework the documentation and attend meetings over a prolonged duration, and these additional costs to DGA arise from the prolonged duration beyond the initial 4-week scope that they had budgeted for. And he said, we did this, then we kept receiving further information, and the additional costs arise from that time consumed. Now, we say no evidence has been called by the defendant to refute any of the above, and further, the allegations of either clear negligence, which are made in the skeleton, or somewhat shockingly, allegations of bad faith, aren't based on any credible evidence whatsoever, and should be withdrawn. And we obviously vehemently contest those. That's my summary of the evidence, my lord. If I could just
Yes.
turn to a couple of points in Mr. Cody's skeleton argument. He deals with 3 points of UAE law. The first is Article 246, which is good faith, and we say, I've already addressed you on the fact that there's no bad faith here, and in fact no absence of good faith on DGA's part. And further, we say that everything DGA did was in good faith, and that is evidenced by the chronology and the time which it works beyond the end of the initial agreed period. The second point deals with Article 247 of the UAE Civil Code, which is to do with reciprocal obligations. And again, we say that there's no evidence that DGA didn't perform its obligations, therefore this article is simply inapplicable. But if it has any application at all, it should apply in the claimant's favour, and that's because there's a reciprocal obligation of payment in the consultancy agreement, and that was never forthcoming from the defendant. And therefore, if and when DGA stops performing, it was entitled to do so under this article, but really we say this is a distraction, and the court shouldn't concern itself with the fact that any allegation that DGA failed to perform. And then the third submission from Mr. Codith in his skeleton is Article 318, and that's where it is said a party is not entitled to enrich itself to the detriment of another. Now this goes quite close to a serious allegation that the claims being brought by DGA are in bad faith. I've made myself clear on that already and won't repeat it. But again, we say, if anything, this assists the claimant. And that's because if all this work had been carried out by DGA and the defendant is allowed not to pay for it, well, that would be a perfectly good example of the defendant enriching itself to the detriment of the claimant. And therefore, we say that the claim for additional services should stand whether under the contract or on a quantum merit basis.
Yes.
Just the final point I wanted to make was that I took in re-examination Mr. Sharman to the synopsis point, and that makes good both the fact that the lump sum scope was fulfilled, but also that the further work was done and there were rolling requests. And he, in answer to the question in relation to additional services, explained the 4-week window point, explained that this was a high-level report, which we say comes across from the documents and on the face of the consultancy agreement itself. And he explained how typical operation in the Middle East work in terms of a 3 to 4 week preliminary review. And we'd ask the court to draw on its experience and expertise in matters of technology and construction, that it's more or less common sense that in a construction dispute of this nature, one might advise at a high level initially in the way that the report does on its face, but that a more detailed review might be forthcoming once one had focused on elements of the claims that they wanted to review more information. Finally, Mr. Codith referred to a huge loss allegedly caused to the defendant. This is first alleged in his skeleton argument and then repeated in his questioning and cross-examination. And the claimant's position is that this claim simply shouldn't be allowed as it wasn't pleaded. The defence makes no mention of it. There was no counterclaim ever intimated or raised. And we say it's simply too late to raise an unparticularised, unspecified counterclaim at this stage. So for all of the above reasons, the claimant would invite the judge to prefer the evidence of the claimant's witness, noting that the defendant did not adduce any oral testimony, lay or expert, on its part, and accordingly the claimant seeks the relief pleaded, which is the lump sum payment of the additional services payment and interest.
No, it's the interest. There's no contractual interest. Have I got that right? It's a matter of the usual discretionary interest that the court has jurisdiction to grant.
Yes, my lord, that's correct. And we would simply submit on that the claimant has been unfairly kept out of its money, and the contract does set out the time period for payment, and we have pleaded that, which is 45 days from the date of the invoice, and that one can look at the dates. As I said, I think the invoice is 22nd of September 17, but we accept that it wasn't sent until the 1st of October and then resent on the 8th of October. But if one runs 45 days forward from 1 October as a sensible date, you get to around 15th of November 2017. And we say that interest should run from then at the ordinary rate and ordinary rest that the court has the discretion to apply.
Well, the court doesn't, as a matter of discretion, it doesn't award compound interest, does it?
No, and we're not seeking compound interest, my lord.
No.
Just simple
But,
interest.
if I remember right now, I'm a little bit rusty on this. There's there is a particular rate of interest, which is it's either in a practice direction or there's some kind of announcement of what the rate will be for the purposes of judgment interest and discretionary interest. Are you able to help me on that?
Well, my lord, our primary submission would be that it's UAE law that governs the contract, and therefore it's UAE law that should govern the rate of interest. And the commercial code.
I'm not sure about that, because I think that interest is part of the. This case is brought in the DIFC court. Parties agree that the DIFC court should be the jurisdiction to determine the claim, albeit on the application of UAE law in respect of the contract. Since the contract says nothing about interest, and this claim is brought in the DIFC court, seems to me that it's at least arguable that the relevant rate will be the rate that is generally awarded by the DIFC court in the exercise of its discretion.
My lord, if I may, I agree with you, but it may make little difference, and that's because if I were to address you on UAE law, I would have said that the UAE commercial law and civil code suggests 12%, but the custom is 9%, and then I would have left it at that. And the reason I say it makes little difference is I believe Article 39 of DIFC law number 10 of 2004 specifically allows for interest to be awarded, and that it's for the court to determine the appropriate rate, but practice direction number 4 of 2017, interest on judgment, provides that any judgment of the DIFC courts can carry interest at the rate of 9% or any other such rate as the judge may prescribe.
I see. That's judgment interest.
I was about to say it is. Perhaps I could see if I could find a reference to interest in the ordinary course, as it were, not judgment interest, whilst my learned friend's making his submissions.
Well, it's not uncommon for the judgment rate to be applied to the pre-judgment debt, if you see what I mean.
Yes, my lord.
I would, I think, be assisted by some guidance as to the approach taken in the UAE. I think you mentioned 12%, and then you mentioned 9%. Can you go over that again for me?
Yes. So under the UAE Civil Code and Commercial Code, there are various provisions relating to interest. And in relation to the Commercial Code, Article 76, it says that a creditor shall have the right to demand interest on a commercial loan in accordance with the rate stipulated in the contract. If the rate of interest is not stipulated, then it should be calculated in accordance with the rate prevailing in the market on a condition that it does not exceed 12%.
Right. And then it's commonly in the market it's 9%, is it? Yes,
that's correct. And when I say in the market, I should be very clear that the well understood practice of the court, and there's various courts of cassation decisions, so one could look at case number 266 of 2008, where the courts here in Dubai award interest on the full amount at the rate of 9% from the date of commencement of the proceedings, and then the court of
the onshore courts of Dubai.
Yes.
Yeah.
but then the Court of Appeal then refined that to basically start the date that interest ran from as the date, as we'd expect in this case, that the obligation was due, so a payment. So here, 45 days after the invoice, and the Court of Cassation confirmed that and upheld the decision, and it cites the various elements of the commercial transaction law, and it says it is established by judicial custom in the Emirate of Dubai to calculate interest by the rate of 9% per annum, and that's where it arises from.
Yeah, good. Yes, anything else?
Nothing further from me, my lord.
Right, thank you. Thank you, Mr. Kodos. Do you want a period of time to reflect, or are you ready to make your closing submissions?
Pardon your apologizing, Your Lordship. I can make a statement.
I'm asking you whether you'd like a short period of time to take on board what Mr. Tolley has submitted, or whether you're ready to make your closing submissions right now. So it's your choice. Yeah,
now I can make it to you. I can make it.
You make it now.
Yes, Your Lordship. Thank you, Lord. Thank you, Your Lordship. Your Lordship, as stated in the statement and as stated in the Skelton argument, I reiterate that the claimant has failed to, is not entitled to get any remuneration, consultant fees of 130, only because of the fact that they have not carried out the work as per the scope of work as encompassed in the Schedule 2 of the agreement, Your Honor.
Yes.
And the reports filed by the, obviously, the report filed by the claimant was no way useful to us to put up our claim before our, to put up our legitimate claim before our contractor, Your Lordship.
Yes.
So the claimant was terribly failed to advise upon the true settings of variations, claims, and other entitlements available to us in the project. They also failed to advise on how to mitigate the LDs or penalties which was imposed upon by the China state. Eventually, there was an amount of 23 million was due to us from China state, was not paid to us. Eventually, we set up the amount to 23 million with the China state against the LDs and penalties. We don't receive even a penny from the due amount of 23 million euro, Your Lordship.
Yep.
And one more thing I would like to bring to Your Lordship kind attention that Section 5 of the Concession Agreement, which says that for additional services, it states that 5A1, with the consent of the consultant, not to be unreasonably withheld or delayed, the client shall be entitled to instruct the consultant to perform services outside the scope of standard service. Because for which they need our consent. We did with the consent, we can request for their consent first, consultant consent. And we never instructed to do any additional work outside the scope of work. It was not happened. This procedure was not happened. So therefore, their claim is that they are entitled for additional remuneration for additional work. It will not accept. It just will not stand, Your Lordship.
Yes.
Because with the consent only they can work on it. They never took our consent. We never advised also. So what we in the email of Mr. Stam on 28/3, which is mentioned by Mr. Nick, 28/3 of March 2020, where we advised to do rework of the work which contained in the original scope of work, not additional work, it is rework only, not new work, because the report was missing so many important items, so many important assignments. So we requested them to do rework upon the report file. This is not a new work. It is within the additional scope of work only. So
yes.
what I am submitting before the Lordship, the petition filed by the claimant may be dismissed with the cost compensatory quote to us. The petition for this one, petition for the original claim amount of 130,000 and 264,350 for the additional remuneration paid by them, and damages and interest.
Yes.
Lordship,
well, thank you very much, Mr. Kodos.
Yes.
Does that?
Sir, let me, Your Lordship, let me bring to your notice that UE law, UE Civil Code, Article 254, 250, 246, it states that, let me bring to your,
Sorry about that.
let me bring to your kind notice that UE law 256 of Civil Code states that the contract shall be implemented according to the provisions contained therein and in a manner consistent with the requirement of good faith. Second, the contract is not restricted to what is contained therein, but shall extend to its essentials in accordance with the law, custom, and nature of the business. So here consultant claimant failed to deliver its service by using the expertise in this field as per the requirement, as per the scope of work, which terribly affect us. Even affected the, even our company's existence was in peril for some times because of the, because of our inability to recover the due amount from the client, from the contractor. So we suffered a lot based on that. So we were not able to, in a position to pay the consultation fees to this claimant. We have huge loss in terms of money, in terms of reputation, everything. So everything in a company situation was in peril for some time, and even now you have not recovered from that peril. That may be taken note of, Your Lordship.
Can you remind me again of the article of the UAE that you were referring to? It was Article 25, what was it?
246, Your Lordship. 246.
Okay, thank you. Thank
Okay.
you.
And Article 247 of the UAE, which says that in bilateral contracts where the reciprocal obligations are due, each of the parties shall have the right to abstain from executing its obligation in case other party does not honor its obligations.
Yeah.
Here, this clause also is squarely applicable to our case because they never able to give a report as per the scope of.
Yes.
So, which put us in a position to not to pay them, not to able to make the payment.
Yes.
The very intended purpose for which the consultant, the claimant was appointed, was defeated from the foot itself. So yeah. I respectfully submit before Your Lordship that the suit may be dismissed with the cost. The suit for additional claim may be dismissed with cost and damages and interest.
Yes.
And you are pleased to note that Article 318 of the UAE Civil Procedure Code, which may make it very specific that no one is entitled without a cause to enrich himself to the detriment of another person without just a cause. Here we were not benefited by the so-called report filed by the claimant, Your Lordship. We were not benefited at all. We could not raise any claim, any variation, nothing against the contractor, the very purpose for which they were appointed.
Yes.
That's all, Your Lordship. So I expect to submit Your Lordship. The suit may be dismissed with the compulsory court to the defendant.
Well, thank you very much, Mr. Kodoff.
Thank you very much, Your Lordship. Thank you very much, Nikki.
Yes, well, I'm grateful to both of the representatives for each of the parties for the concision and economy that has marked their submissions. That has been very helpful because with the time difference between London and Dubai, the hours available for this hearing are less than would otherwise be the case. And it means that we don't have the inconvenience and the expense of having to go into a second day. So I extend to both counsel the court's gratitude for the approach that they have taken. I have quite a lot to think about, and I'm going to look forward to the transcript, which I think will be available, if not tomorrow, well, the following day. And I shall endeavour to produce my judgment as quickly as I'm able, given my other commitments. and bearing in mind that this is a dispute that's been going on in terms of proceedings since 2019. So the earlier it's decided, the better for everybody. And therefore, I'm shortly going to draw these proceedings to an end. I would like to have a word with Matha, the case progression officer. Matha, can you hear me?
Yes, Judge, I can hear you.
Oh, thank you very much. I would like the transcript as soon as it's available, please. If you give that a little shove in favor of expedition, I would be grateful. Good. Well then, this hearing is now concluded. I reserve judgment and will produce my judgment as soon as I reasonably can. Thank you both very much.
Thank you very much.
Thank you. Bye-bye.
Bye.
Thank you, Lordship. Thank you, Lordship.